Today, we're going to talk about something that many people in personal injury cases might be worried about: the deposition. If you haven't been through one before, it can be pretty intimidating, but Andrew here is going to help break it down for us. Andrew, the deposition is pretty important to your case, isn't it?
Yes, I think it's probably the most important piece of a plaintiff's personal injury lawsuit because it's usually the first time that the insurance company's attorneys get to talk directly to you in your case. And it's their opportunity to ask you questions about your injuries and how the accident happened.
Okay, so first things first, let's define what a deposition is. Is it like a courtroom trial?
It's not. So the judge isn't there. There's no jury. Generally, these days we're doing them all on Zoom. What we often have is our clients come into our office and sit at our conference table, and then set up a webcam. So I'm with our client in the room, but the insurance attorney is somewhere in their own office, appearing on Zoom. And then the only other person, usually in a deposition, is going to be a court reporter who is there to transcribe all the questions that are asked and all the answers that are given.
Okay, so what is the most important thing someone should remember when sitting down for their deposition?
The key is honesty, and I can't stress this enough. Your credibility is literally on trial, and the insurance company's attorney is looking to see, are you credible? Are you being forthcoming? Are you honest? Are you evasive in your answers? And if you're not telling the truth or you're giving incomplete or inaccurate statements, even if you're forgetting things, it can really undermine your case. And so one of the things people need to keep in mind is if you're asked questions you're unsure of, it's much better to not guess and say things like, I don't know, or I can't recall. Because again, your credibility is the most important key to your personal injury case.
Got it. So it's okay to admit you don't know something.
It is. There will be a lot of questions you're asked in a deposition that you probably don't know, whether it's specific dates or times of things. And saying I don't know is an okay response in most instances.
Good to know. Good to know. So let's talk about the way that you answer. Now, I've heard that you shouldn't say too much. Is that right?
Yes, keep your answers short and to the point. If you're asked a yes or no question and you can answer it yes or no, answer it yes or no. Normally, if you're going on and on, you're just going to get more questions asked, and all the details that you're giving in there will just create more questions and make your deposition go a lot longer. So getting right to the point, again, not being evasive and just answering the question is really going to be one of the best tools you can have during a deposition.
So no long stories or extra details, just stick to answering the exact question that was asked.
Exactly. Keep the answer short and answer the question. If you're unsure about what's being asked, it's okay to ask for clarification, either asking for the attorney to rephrase the question or just telling them you don't understand their question, and they will rephrase it.
So I've also heard that using words like always and never can cause problems. Is that true?
Yes, I think absolutes are always very concerning from an attorney's perspective. Attorneys are very particular about the words we use, and the words our clients are using. And even honestly forgetting something can be very detrimental for your case. So a common thing in a personal injury case might be the attorney asking you, let's say you have a neck injury from a car accident. They would ask, well, have you ever had neck pain before? And you might think, well, I never remember it. I never remember going to a doctor for neck pain, and just want to say, nope, absolutely not. I've never had neck pain before. And then lo and behold, they find some record from 20 years ago when you were 14 that shows you had neck pain. Maybe you were at the Centricare for a cold and your neck felt stiff or something. So just being careful not to get into these absolutes where then the attorney can even take to an extreme sense, trying to undermine your credibility. So using phrases like, not that I can recall, or, I don't remember ever having that, If that's the truth, then leaving it at that. Just because, again, even honestly forgetting things can be detrimental.
That's super helpful. So keeping things honest is the key. Avoid absolutes. So now, what about when it comes to talking about how the injury has affected your daily life?
This is my one exception to keeping your answer short and simple. This is your chance to explain how your injury has affected your daily life. And I think having concrete details on just the daily activities, the things that you're unable to do or unable to do as well. Having as many examples of that in your deposition can be very helpful. One, in helping me to advocate, but also in explaining really kind of the human side, the human damages of how this injury has affected your life. And so, like I said, generally speaking, answer the question nice, short, and simple. But when you're asked questions like, tell me all the things that you can't do because of your injury, or tell me all the things you can't do as well because of your injury, try to give as many examples of that as you can.
So you would say something like, before the accident, I enjoyed hiking, but now I'm unable to hike.
Yeah, or for many people, or they hike now, but they have pain and they're icing, their back or their neck or their knee, which was injured in an accident. But even more than just sort of the common things people often think about are like, oh, well, I used to go skiing and now I don't ski. But how often were you skiing? Maybe you're skiing once or twice or once every 4 years. It's a good example, but it's not really showing how it affects your daily life. What I like to hear are things of just things around the house or interacting with your children or how you and your spouse, how it might have affected your relationship there. Because I think those are the things that a jury ultimately will connect with much more than, again, the rare occasion you went on a trip to Utah to go ski.
So it's things like, you want to provide examples about daily chores, like, I used to unload the dishwasher every day, but now my teenager has to do it because it hurts too much to bend over. Is that what you mean?
That's a great example of, again, something that to most people initially it seems like, oh, well, that's not significant, but those little things really do add up. And again, shows how an injury can really change just your daily interactions and your mood and how you feel. And that's, again, kind of what we build a case around.
So concrete examples can really paint the picture for the other side.
Yes.
So honesty, clarity, and being specific, that's the way to go?
Yes. And remember, try not to be overwhelmed by the process. We sit with you through the deposition. I like to spend time one-on-one prior to the deposition to, again, talk over specifics for each client. As intimidating as it can be, it is very useful and very important to seeing how your case will progress and ultimately, hopefully, get a good resolution from.
That is awesome advice. Thank you, Andrew. Thank you to Andrew Irvin for breaking this down for us today. I'm sure this will help a lot of people who are nervous for their deposition.
Yeah, and I'm glad to help.
So if you're going through a personal injury case, remember that honesty and preparation are your keys to a successful deposition. We'll see you next time.